Further, we are reading from this part that will be applicability of the code section 2. तो यहाँ तक तो we have already read that what are the other expected impact and benefits of the amendment in code are lesser than the burden on adjudicating authority, assure continuity of business operation for corporate debtors, less process cost and maximum asset realization for the final creditor FC, and assurance of continued business relation with CT and right protection for operational creditors. तो यहाँ तक तो हमने पढ़ लिया था. Further we need to read from this part applicability क्या होगी of code section 2 की. The provision of code shall apply for insolvency, liquidation, voluntary liquidation or bankruptcy of the following entity. So provision है of the code, हम क्या बोलते हैं कि जो भी provision है of the code shall apply for वो apply होंगे insolvency के लिए, liquidation के लिए, voluntary liquidation and bankruptcy of the following entities. Any company incorporated under the Companies Act 2013 or under any previous law, कोई भी company जो कि incorporate हुई है under the Companies Act 2013 और under any किसी previous law में, या any company which is governed by any special act for the time being in force except in so far as the said provision is inconsistent with the provision of such a special act. Then any limited liability partnership under the LLP Act 2008, any other body corporate under any law for the time being in force as the central government made by notification specify in this behalf, personal guarantors to corporate debtors, partnership firms and proprietorship firms, individual other than the person referred to in clause E. Company governed by Companies Act 2013 under any previous law by or any special act. Then LLP, the notified entity, personal guarantor, two corporate debtor, partnership firms and proprietorship firm, individual other than the personal guarantors. उसके बाद क्या है SC in Lalit Kumar Jain versus Union of India in 2021 held with respect of the application of code that there is a sufficient indication in code by section 2E 522 section 60 and 179 indicating that जो personal guarantor होता है through forming part of larger grouping of individuals are to be in view of their intrinsic connection with corporate debtors dealt with differently through same adjudicating process and by same forum as such corporate debtors. Personal guarantors of corporate debtors have been treated as a separate class. So application for the bankruptcy of individual personal guarantor will have to be filed before NCLT as per section 60 subsection 2 of the IPC 2016. So insolvency code here that the same has been made applicable to personal guarantors of corporate with this notification dated making provision of IBC applicable in respect of personal guarantors to corporate debtors as another category of person is valid. Even the approval of a resolution plan does not discharge the personal guarantor of a corporate debtor of her or his liabilities under the contract of guarantee. Then comes that what will be the known applicability of the code. Known applicability of the code क्या होगा? The code is not applicable to corporate and finance actor. Section 3 clause 7 of Insolvency and Bankruptcy Code 2016 state that corporate person shall not include any financial service provided. Corporate person में कोई financial service provider नहीं आएगा. Financial service provider means a person who is engaged in the business of providing the financial service in terms of authorization issue or registration granted by a financial sector regulators. However, section 227 जो है of the code which was जो कि notified हुआ है on 1/5/2018 को provided that central government can notify कर सकता है financial service providers for the purpose of insolvency and liquidation proceedings which may be conducted under the insolvency and bankruptcy code in consultation with appropriate financial sector regulator. As per the notification dated 18/11/2019, it has been notified by the central government that insolvency resolution and liquidation proceedings of loan banking finance company which include housing finance company with asset size of 500 करोड़ उससे ज़्यादा मतलब NBFC जिसकी worth 500 करोड़ और उससे ज़्यादा हो or more as per the last audited balance sheet shall be undertaken in accordance with the provision of code and the rules made thereunder. National Company Law NCLT Mumbai Bench in 2022 decided in the State Cooperative Bank Limited versus Sri Siddheshwar Sahakari Sakhar Karkhana Limited that corporate status being a cooperative society was not a corporate person to whom provision of code were applicable. Here as corporate debtor was registered incorporated under Multi-State Cooperative Society Act 2022, which provided specific statutes for winding up of society registered under same, and hence corporate debtor could not be put under insolvency resolution process. Important definition which have been used here, that is the section 3 say 5. Section 3 say 5 board means the Insolvency and Bankruptcy Board of India IBBI established under section 188(1) of the code. Section 3(1) the board shall be the body corporate by the name aforesaid, having perpetual succession and a common seal, with powers subject to the provision of this code to acquire, hold, and dispose of property, both movable and immovable, and to contract, and shall by the said name sue or be sued. Section 188 subsection 2. The board will have powers of civil court as to the issue of summons, discovery and production of books, inspection of books, registers, and issue of commission for examination of witness. Section 196 subsection 3 of the Code. Charge means an interest or a line created on the property or assets on any person or any of its undertaking or bond, as the case may be, as security, and includes a mortgage, that is section 3 subsection 4. Then claims means a right to payment, whether or not such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured, or unsecured. Right to remedy for breach of contract under any law for the time being in force, if such breach gives rise to a right to payment, whether or not such right is reduced to judgment, fixed, mature, unmature, disputed, undisputed, secure, unsecure, section 3, subsection 6. Then the corporate person means a company is defined under section 2, clause 20 of the Companies Act 2030. A limited liability partnership as defined in 2 subsection 1 of LLP Act 2008. And any person incorporated with LLP under any law for the time being in force, but shall not include any financial service provider. Corporate debtor means a debtor person who owns a debt to any person. Corporate debtor means a corporate person who owns, जिसे देना है, a debt to any person. Creditor means a person to whom the debt is owed and include a financial to whom जिससे debt, a financial creditor, an operational creditor, a secure creditor, an unsecured creditor, and a decree holder. That means a liability or obligation in respect of a claim which is due from any person and includes a financial debt and an operational debt. Financial debt means a debt along with interest, if any, which is disbursed against the consideration for the time value of money and includes money borrowed against the payment of interest, any amount raised by acceptance under acceptance credit facility or its dematerialized equivalent, any amount raised pursuant to any note purchase facility of the issue of bond, notes, debenture, loan stock, or any similar instrument. The amount of any liability in respect of any lease or hire purchase contract which is deemed as a finance or capital lease under Indian accounting standards or such other accounting standard as may be prescribed. Receivables sold or discounted other than any receivables sold on non-recourse basis. Any amount raised under any other transaction including any forward sale or purchase agreement having the commercial effect of borrowing. Explanation: for the purpose of this subclause, any amount raised from an annuity under a real estate project shall be deemed to be an amount having the commercial effect of a borrowing, and the expression annuity and the real estate project shall have the meaning respectively assigned to them in section 2D and this of the Real Estate Regulation Development Act 2016. Any derivative transaction entered into in connection with the protection against or benefit from fluctuation in any rate or price, and for calculating the value of any derivative transaction, only the market value of such transaction shall be taken into account. Then comes any counter indemnity, obligation in respect of guarantee, indemnity, bond, documentary letter of credit, or any other instrument issued by a bank or financial institution. उसके बाद the amount of any liability in respect of the guarantee or indemnity for any of the item referred to in subclause A to H of this clause, section 5 subsection 8 of the code 2016. Subscription money for purchase of share is not financial debt. Subscription money for purchase of share is not financial debt. ACPC Enterprises versus क्या Affinity Beauty. हाँ